Hi, and welcome to the Animal Welfare Junction. This is your host, Dr. G, and our music is written and produced by Mike Sullivan. Today's guest is a repeat guest, Dana Pannella. Welcome to the Junction again.
Thanks for having me again.
The last episode that we talked about legal things, and we're here to talk about more legal things, but more current. We're going to be talking about Avery's Law and why things need to change and kind of how things have changed. Let's start in with a definition of what is a dangerous dog.
Yeah, so the definition of dangerous dog has changed with Avery's Law from what it originally was prior to HB 274 being enacted. So the new definition now says that a dangerous dog is one that has committed an act without provocation, and the acts are causing injury by physical contact other than killing or serious injury to a person in either a menacing fashion or an apparent attitude of attack. Number two, causing serious injury without making physical contact to any person in either a menacing fashion or an apparent attitude of attack. Number three, killing another dog. Or number four, causing serious injury to another dog that results in the euthanasia of that other dog. In addition to that, there are two other categories that also existed prior to 247, which are the nuisance dog and vicious dog designations that have different definitions.
What are we talking about as far as what defines the injury to a person from these dogs?
An injury is exactly that. It is any injury to a person. It's not just a bite. It could be a scratch, a bruise. It could be knocking somebody over and they nick their hip on a concrete curb. And that's one of the major risks of this language is it is not just a bite. It is any injury to a person.
So, in essence, if I'm somebody that is naturally afraid of dogs and I see a dog coming at me and I go running away and I trip and fall and crack my head, then that dog can potentially be considered a dangerous dog.
Correct. And the risk of the language is that we say it has to be in either a menacing fashion or an apparent attitude of attack. Well, typically that's going to be from the viewpoint of the person who is affected. And that person may have an unnatural fear of dogs that causes them to run out into traffic and get hit by a car. And we may have a very happy golden retriever who just wants to say hi, and now they're declared a dangerous dog. This language is extremely risky for dogs.
What is it that started Avery's Law?
There was a dog attack in Reynoldsburg, Ohio, a few years ago that involved a child who was badly mauled by dogs that were owned. These were not stray dogs. They were not dogs at large. These were owned dogs. And as a result, the legislature felt that the existing dangerous dog law did not sufficiently address what had happened to Avery Russell.
So in my experience, in my opinion, is that there's been a long time where rescues and shelters and even pet owners have had dogs that would be considered dangerous and have not done something about it. And even though there were laws that were made to make dogs be dangerous dogs, if there were any instances or and things, those nothing was being done.
Yeah, and it's not that the law we had before didn't necessarily work. It's just that we didn't necessarily have law enforcement applying it the way they could have, in my experience. So, one thing we have to remember is that in Ohio, dog wardens have absolutely no training that is state mandated. So, sometimes when they get hired as a dog warden, they go to the shelter, they get a catch pole, and they get their uniform, and they're out in the field the next day. They have no training on dog behavior, they have no training on dog handling, they have no training on how to enforce the laws. And that's a big miss. Even today, it's still a big miss because they still have no state mandated training. So the law we had prior to Avery's Law wasn't necessarily a law that didn't work, but it was a law that was not being enforced properly. We've heard a lot about how, Avery's Law has made some changes. In reality, most of those changes are not changes at all. Prior to Avery's Law, dogs could be euthanized for committing acts through the existing criminal process. Dogs could be seized if there was an act that warranted them to be seized and taken into a dog shelter and held in custody. None of that really changed with Avery's Law. However, what Avery's Law did was it tried to make the law more explicit. In some ways it did, in some ways it didn't. But it is a misconception that the law we had before didn't work. It did work. It just that it wasn't being enforced. And, that's something we commonly see with a lot of laws, including the animal cruelty laws. We have people saying, oh, our laws aren't strong enough. they're not strong enough. Well, actually they are, but it's the way that they're being enforced that may not be strong enough, or the way they're being interpreted. So similar situation here. I believe everybody can agree that we don't want dangerous dogs out on our streets or dangerous dogs in homes harming people, but I think we've missed the mark as far as actually creating an effective system to address that.
Yeah, I think that things like the no-kill movement, for instance, right? Like a lot of people, places, shelters, and even pounds are afraid to euthanize dogs because of the perception, the community perception on what that means, and then that has caused warehousing of animals to where so many shelters have a lot of animals that they can't move because they can't get adopted, but then those animals are taking up space, so other animals cannot come in, and the dog warden as a job is supposed to be public safety, right? So they're supposed to be taking care of these aggressive animals and they have not been doing their job. So I mean it is like you say a huge mess.
Yeah, as someone who works in this field, we often see the fire that is brought down upon dog wardens and municipal animal shelters and even nonprofit shelters when they euthanize a dog. As a society, we have to begin accepting that there are dogs who cannot safely be put out into the public. And those dogs are, in fact, probably suffering in the conditions they are kept in because mentally they are suffering. Just because they're not physically suffering does not mean they're not mentally suffering. And we have to begin to think about that when we think about dogs, is that sometimes it is compassionate to euthanize those dogs. But also, there's a public safety aspect. Keeping dangerous dogs around and putting those dogs into homes or keeping those dogs in the homes they're in means that we'll continue to see situations like Avery Russell's because we are not addressing the problem. No one wants to euthanize dogs, right? Nobody likes doing that. It's terrible, it's sad. But the bottom line is for every dog that we don't euthanize and we know we should, and that dog goes on to commit an attack, we are harming a dog that will never do anything wrong because the effect is a ripple effect. When people see that dogs are being adopted out of dog warden facilities and rescues and other shelters that are dangerous, that has a ripple effect for people who are thinking about adoption. Well, should I adopt a dog or should I go and get one from a breeder? Should I go and get a quote unquote undamaged puppy instead of adopting one from the shelter? That's the ripple effect that a lot of the times we don't think about when we are considering, should we place a dog with this history?
Yeah, and one of the things that I have seen in some of the places that we travel to is that there will be dogs that are like, are for adoption, but to a specific family because there are certain triggers, and the dog is doing okay in the shelter under these circumstances, and then the dog will get adopted, and something will happen at that home, and then it gets returned, but it's a rescue favorite, so then it just keeps happening and happening and happening, and living in a shelter, living in a run is just no life for dogs like these.
Yeah, I mean, we're failing dogs ultimately is what we're doing by keeping them around like that. And we're failing people too. And, everyone has their own risk tolerance for, whether or not they believe a dog should be placed. But I think most of us, if we've been around dogs long enough, we know deep down inside whether or not a dog should be placed. Is it unreasonable to believe that a dog who can't be around children, can't be around other dogs, can't be around cats, can't be around other animals, female only home, is that a reasonable dog to place?
Right.
And who are we harming in the process? We're harming all the other dogs who don't have 15 restrictions, who are unlikely to perform an act that will have them classified under a law like this, or who will result in a lawsuit and shut down your shelter or shut down your rescue. Because those are all very real risks. Beyond the criminal penalties, there are civil lawsuits, right? And we've seen them across the state. One wrong move, one wrong decision can end your entire program. We have to start being smarter about the dogs we're placing.
Yeah, I like to tell people as far as, behavioral euthanasia is a pretty hot topic, especially with veterinarians, because a lot of veterinarians don't like to do it. And there are some veterinarians that, it's you haven't tried hard enough or you haven't done enough. You have not used the right medications or you need to go to a behaviorist. And we're putting that risk back on the owner. Like we have somebody that's making a hard decision to euthanize their animal who they probably love, but they understand that there is a risk and placing them is just passing the buck and giving that risk to somebody else. And all like me for me personally, again, I don't enjoy euthanizing dogs, but I see cases like this case that I want to discuss with Pickaway County where dogs could have been humanely euthanized, but instead they were shot to death because, as you said, humans failed them.
And there's a pit bull attack. It just attacked two dogs, and it started attacking a woman who ran, and it killed one dog, and it's in roaming in the neighborhood behind the middle school.
Okay, did it attack anybody or just the dogs?
It started attacking. A lady walked up to help. I'm sorry.
Tonight, we're getting new details surrounding a deadly attack involving two Pickaway County pit bulls. A 73-year-old was killed.
Now, it turns out these dogs had a history of problems. On Your Side investigator Lisa Rantala uncovered previous reports of the dogs running loose while high on cocaine. Lisa, this is a wild story.
Guys, we're looking into what took place at the Ashton Village condos before 73-year-old Joanne Eckelbarger was killed outside of her home last week. We want to know why, after a judge ordered those pit bulls be removed weeks ago, that it never happened.
This case happened here in Pickaway County where two dogs got loose and killed another dog, and the HOA was sued by the dog owner, and the HOA wanted to get rid of these dogs, and the system was just not moving fast enough. But then finally the judge said, yes, those dogs have to be removed, but the dog warden didn't remove the dogs. And then the dogs ended up getting loose again and killing the next door neighbor lady who was just outside gardening, like completely innocent bystander. And then these dogs go running around and end up getting shot. And all because the dog warden kind of didn't do his job. And as you say, he may not have known how to do his job.
At the same time, the Pickaway County dog warden tried to file charges against Adam Withers 3 times involving violations to ordinances with dangerous dogs. Some penalties of these ordinances could mean euthanasia. Each of his cases were dismissed, the last one in August. The current law director told me today that the charges were filed under the wrong subsection of the law. This is what the dog warden told us last week.
I think it is a learning thing. There's a lot of people that need to learn if that's coming into the job, if that's still into the job. But I mean, we take every case extremely seriously.
But some of these things are just common sense, right?
Yeah, I mean, it's a problem we're seeing consistently, and it's not just dangerous dogs, but it's dog wardens who are generally refusing to pick up stray dogs because they're full. Well, some of those situations are going to escalate into things like we've seen in Pickaway County and elsewhere, and they will have more devastating results than simply having taken those two dogs to a veterinarian and having them euthanized in the first instance, or having them be taken to training, a behaviorist, making any kind of attempt to address the behavior of these dogs. So there's a lot of failures, right? There's the failure of the owners who knew that those dogs got out and killed another dog in their community. And what did they do to address it? We have the dog warden who could have, under existing law, designated those dogs as dangerous, even prior to Avery's law. Didn't happen. We have the HOA who made some efforts to remove the dogs, but were ultimately unsuccessful. So there's just a lot of failures here where the situation could have been addressed and was not, and it ultimately resulted in the death of an innocent woman. That's exactly the kind of stuff that we have to stop from happening. And I still don't think we're there. We're just not there. So, you know, I think unfortunately we are going to continue to see these attacks and not necessarily be fixing the problem along the way.
And I think that the whole issue of just leaving dogs remain strays, we're talking about, you know, allowing community dogs, and that's like a whole other topic. But it can be so dangerous because some of the people that are for this are like, well, cats do it, and cats are not dogs. Cats don't go out in packs and, you know, try to kill another dog or, you know, try to do other things. Also, it's easier for cats to find sustenance. Like, you cannot expect these stray dogs, especially if they start forming packs, to find somewhere to eat, to not be a nuisance, and to not be dangerous to animals and to people.
Yeah. So, I mean, cats are a different species altogether. They have different survival instincts that dogs do not have. Dogs are really scavengers. So to say that we can have community dogs or to think it's okay that we can leave dogs out on the streets is an unacceptable solution to me for a lot of reasons. It's unacceptable from a public safety perspective. It's unacceptable from an animal welfare perspective because those dogs will suffer. They will. So the question is, do we leave them on the streets to suffer? Or do we do what is kindest and bring them into a shelter? And maybe that results in euthanasia. Maybe it doesn't. But I don't think the solution is to say they're okay living on the streets.
The mentality is other countries have community dogs. Well, I went to Mexico and they don't want community dogs. They coexist with them and they deal with it because it's everywhere. It's so prevalent, but they don't want that to be a thing. I was just recently in Romania and it's kind of the same thing. They have dogs that are in the street everywhere. Everywhere that you drive, you see these dogs and they don't want them to be outside. They don't want them to be homeless.
Yeah. I was in Morocco and there were street dogs there and not one of them looked good. And the people were scared of them. And they also, of course, have a lot of rabies, which they refer to as rage. And that causes them to be scared of the dogs and the community cats for that matter, but the dogs more so because they're actively biting people. It's just simply not a solution. I wish it was as simple as saying, you know, we can spay and neuter them and leave them on the streets. It's not reality. It's simply not reality. And, you know, we have to come up with other solutions. Should there be high volume spay neuter? Absolutely, right? We should absolutely be doing that to help these dogs not end up on the streets to begin with. But when they're there, the solution is not to leave them on the streets.
Yeah, in this case in Pickaway County, you know, the dogs are killed, the next door neighbor lady is dead, and then the owners ended up going to prison for, I believe, involuntary manslaughter. And everything could have been avoided if people have done what they needed to do.
Yeah. I mean, now they're in prison when this could have been avoided. Again, I understand they probably love their dogs very much, but as dog owners, we have responsibilities, especially after we know that our dogs are capable of committing acts that are dangerous. You know, we have that responsibility to say, okay, stop. How do I address this? That's our responsibility. It's also our responsibility to acknowledge it before it happens, right? Most dogs don't do these things out of nowhere. There's some buildup. They show signs. They do all those things. It's our responsibility to know our dogs and to know those signs and intervene before things get worse, either by talking to trainers or veterinarian or, you know, someone else with experience with dog behavior to try to address those issues. Otherwise, you may find yourself in jail or in prison. What Avery's law did do is it elevated some of those offenses to higher degrees of crimes. So you could see significant jail or prison time as a result if your dog does something, which on one hand is somewhat unfair because the law does cover not only people who are holding the leash at the time the incident happens, but it covers even people who aren't there. So for example, if you leave your dog with a dog sitter and you're in California and your dog bites somebody, you can be charged for what happened while your dog sitter had possession of your dog. So stuff like that, I think, you know, doesn't necessarily meet the reality of being a dog owner, and it's not necessarily fair to dog owners. But regardless, you're responsible for what your dog does criminally as well as civilly. So you do have to be careful of that. And if not for your dog's sake, for your own sake, I guess, you know, because look what could happen if you're not addressing this stuff.
So before, from my understanding, if my dog was aggressive and it got out and it harmed another dog, then I could be responsible for the medical care of said dog, but nothing really happened to me other than maybe failure to confine or failure to control or maybe failure to license, but there wasn't anything more. So does Avery law change that now?
It does change that because it now covers any injury to another dog. Which I think was a big miss that we had on the original law, because of course, okay, am I saying the dog should be, you know, euthanized at that point? Maybe not. However, it's a big warning sign, right? If your dog causes an injury unprovoked, and I'm talking about an actual injury here. So not a scratch, I'm talking about a bite.
Right.
You know, bites another dog without provocation. That's a red flag, something that we should have been addressing, you know, as a precautionary essentially of now we must recognize this dog may have an issue that we have to address. And one of the things we're still kind of missing here is no requirement for training after your dog is designated. And there's no way to ever get your dog declassified. So really the incentive for dog owners is to euthanize the dog they have and go and get a new one and probably do the exact same thing. And they will never learn how to do anything differently. Whereas if we had a declassification system, they could work towards some goal of eventually having their dog no longer be declared dangerous, nuisance, or vicious. That's fair. They take their dog to training, they have a trainer sign off and say, you know what, this dog has done all the things it needs to do. The owner is an appropriate handler, and they go back to a court and apply to have the designation lifted. That gives them an incentive to fix their knowledge and their dog's behavior. Whereas right now that incentive doesn't exist. It's simply, maybe I keep the dog, maybe I don't, maybe I just go get a new one. But in the process, I've learned absolutely nothing about how to address this issue going forward. So that's, certainly an issue that, we'll continue to see happening. Some other misses here as far as, effective restrictions, we still have the 6-foot chain link leash as one of the requirements. Well, Dr. G, if you've ever handled a dog on a chain link leash, you know that it's not very easy, especially at 6 feet long. It makes no sense. Even with the original law, I feel like they didn't have anyone actually involved with dogs involved in that process. Dog trainers, veterinarians, anybody who has experience with dogs. So we've missed that. We've missed an effective way to, control the dog once they're declared dangerous. We've also missed certain, notifications. I actually worked on a dangerous dog law in a city in Northeast Ohio after they had an attack that occurred, and they wanted to pass their own local ordinance to better address the issue. And one of the first things we did was make sure that people in the neighborhood knew the dog was dangerous. And it wasn't just signs. It was the dog had to wear fluorescent collar, harness, leash to identify that dog when it's out on the street as being a designated animal. They also had a registry. So all of the dogs who were dangerous in their community went on a publicly accessible list. So you knew which dogs in your neighborhood you might want to avoid. So some common sense steps there that would help to make, a law like this more effective, that we're still not quite there yet. But, the bottom line is there are some increased criminal penalties, regardless of how effective the law is or isn't, that can really result in significant jail time and prison time. Now, I believe those owners in Pickaway County were not charged under the dog code. I think they were charged with manslaughter and some other offenses. They could have potentially been charged also under the dog code, even prior to Avery's law. But as you can see, in addition to Avery's law, there are other offenses that still may hold dog owners accountable.
Would the owners also be able to be charged with some form of animal cruelty or neglect if something like this happens to the owner of the aggressive dog? Because in my eyes, if I have a dog and I do not, if I don't take care to keep him from attacking someone or getting loose or something like that, and something happens to it, I'm kind of responsible for what happened to that dog, right?
Yeah, only in my fantasy world.
So, we've been talking about kind of like how this affects the owners and then about the dog wardens. But this law now involves a lot of people that may or may not be related to the dog. And that's one of the things that I definitely want to talk about. As a veterinarian, I see veterinary clinics that are refusing to see dogs that may bite or that may be dangerous because of the liabilities that they may incur. Us personally, our job is to spay and neuter and do wellness care. So we figure out ways to safely manage these dogs. So what are the risks that veterinarians are taking by seeing dogs that have known bite risks? Let's start with that.
Yeah, so this is, again, I think a language problem that we have. Because, again, it says any owner, keeper, or harborer. It's not just the person who owns the dog. It's not just the person who's in control of the dog. It's this whole list of people that could be charged if a dog bites someone. And that includes a veterinarian who has taken a dog into their care that they either know is dangerous or that exhibits dangerous tendencies. If there is a bite while that dog is in the custody of a veterinarian, the veterinarian could be charged. So the fear there for veterinarians is real. And it's not that it didn't exist prior to Avery's law. It's just that Avery's law has increased some of those penalties and brought more awareness to the existence of some of those penalties, right? So there are veterinarians now who are saying, as a matter of risk, I am choosing not to treat those dogs, or I'm going to have the owner apply a muzzle to the dog before I even touch the dog, right? Or they're using PPE or some other, method to result in a better handling experience for that dog. My hope is that we may see some legislative modifications like we have in the animal cruelty law that provides an exemption for veterinarians during treatment of an animal. I think that would be fair. And the same would apply for dog trainers, because we also now have dog trainers who are afraid to take in dogs who've been declared, even if the appeal is pending. So even if the dog has not been finally declared to be a dangerous, vicious, or nuisance dog, they're saying, I don't feel safe having that dog because if something happens, I'm going to get sued or I might be criminally charged. Well, again, that's not really solving any of the problems we have if dog trainers are now afraid to touch dogs with potential histories. So that's a problem. The other problem I've heard is police canines. Sometimes those dogs are boarded. Well, of course they've done things that may, cause them to have a history, or they may be slightly more aggressive or whatever it is. Boarding facilities are now terrified to board police canines. So this kind of stuff, can be addressed through modifications to the bill. And I hope that will happen, because while I understand the intention here was good to fix some of the language, it's caused some unintended consequences along the way.
Yeah, we had a dog a while back, when we had the hospital, that was transferred to us from another facility, and the dog came back and it had a bite quarantine and all sorts of stuff. Well, the dog had been hit by a car and they were doing x-rays and they're moving this dog that is painful, and somebody took the muzzle off and the dog bit them. So, that's a dog that I personally would not consider a dangerous dog. I would consider that to be the current state of the dog. It was in pain, something painful happened, the dog reacted, and it bit someone. Once that dog came to us, we were careful about it, but once he was medicated, then that dog was fine. So, there are some things like that that would be a little bit concerning, because if it bites somebody while it's at my clinic, even though it's not a dangerous dog, then there could be a problem.
Yeah, and that's the problem with some of these definitions. So, we have the provocation defense where the dog was teased or abused in some way, but those terms aren't further defined. So I agree with you. A dog in that situation, when we take that situation from the dog's perspective, is absolutely being provoked. But the law is not that clear. So that dog may be declared dangerous, and then the owner finds themselves in court fighting a designation, spending thousands of dollars, because these are cases where you can't get a court-appointed attorney. You have to hire private counsel to defend your dog who bit in a clear instance of provocation. The law just simply does not clearly list out those circumstances to say this dog is not dangerous. So it just doesn't. It puts, dogs in bad positions, because is it simpler at that point to have your dog euthanized or spend thousands of dollars in court, fighting a designation?
So veterinarians that want to take care of these dogs and want to protect themselves, is there anything that they can do, or what should they be doing to legally protect themselves if an incident happens?
Yeah, so we always suggest doing liability waivers for situations like this, which won't protect them from criminal liability necessarily, but from civil liability. It does provide some insulation, is one approach. And the other approach is just being more conscious about when you're handling and making sure you know the dog's history when they come in. So you could ask the questions that are in the statute. You could ask other questions, about dog sensitivities, things of that nature, to try to avoid these things from happening. But the bottom line is, the more care you can exercise, the better when you're handling any dog, just to try to avoid the risk. So you can use waivers to avoid civil liability. If you have a dog in your possession and it bites your tech, okay, we have a waiver for that civilly. Criminally, not so much. And then it'll be, in the discretion of law enforcement and a prosecutor as to whether or not, that's an offense that moves forward right now, because there is no exception in the law.
And then moving over to the shelters and and pounds, how has this affected them? And what are the increased liabilities that they now have?
Yeah, I think the biggest way this is affecting dogs across Ohio is through shelters, because they take in the highest volume of dogs. They take in so many dogs with unknown histories most of the time. They also maybe take in animals from cruelty cases, dogs who have been previously abused. So that is a really negative consequence of the way Avery's Law is written. And Avery's Law did try to provide some limited protection for shelters who ask a series of questions when they intake a dog, which is fine, but it still doesn't give them blanket protection. It's not a complete immunity clause. It's merely, now did you act recklessly versus negligently? Okay, so you got that little kick up on your mens rea, on your mental state, but it's not a complete protection. So shelters are at the highest risk here from facing potentially criminal penalties in these cases for dogs that they may not have any history on. And that's where it gets really complicated. And I think, there's also probably some amendments that could be made to that, because it simply isn't fair to hold shelters to that standard, the same standard as a normal dog owner would be, dog owners who know their dogs. Now, of course, that's not to say there aren't situations where shelters don't know that they have dogs who are dangerous, because we know that happens too. And I think that can too be addressed through the law. But what I'm talking about are the dogs that they have no reason to believe would ever bite a person without provocation. Those dogs are the ones that I think there should not be criminal liability for. The other dogs where they know because of prior bites or prior behavioral history, absolutely that should be addressed. But right now we have all of the dogs in the same category. And I think we need to create a disparaging system here where some dogs go into a different slot than other dogs do. So that's where it becomes difficult. The other, unintended consequence we're seeing is that the way the law is written, it affects large dogs much more significantly than small dogs, because small dogs like Chihuahuas can never reach the level of being a vicious dog based on the definition alone. There is never a Chihuahua who's going to cause serious physical harm or kill a person. It's not possible. Whereas your larger breed dogs, a serious physical injury for a larger breed dog could be a simple one bite snap and they let go. That could cause a serious physical injury. And those dogs are now subject to euthanasia. And those dogs are now subject to being declared vicious. And all of these things for one bite that may not truly completely encompass the behavior that was occurring there. So, large breed dogs are really the most at risk from these definitions. And I think we're going to see that more so than ever in the dogs that are not leaving our shelters. So less people adopting large breed dogs, less large breed dogs making it out alive. So that's an unfortunate consequence of what we have here. And it's also an unfortunate consequence that animals with behavioral history that we know about, especially from animal cruelty cases, won't necessarily have the opportunity to be rehabilitated, because that's a risk now. So I think, there should be some leeway given for situations like that allow behavioral modification to occur without fear of, while this is in process and we're working with a licensed trainer or a licensed behaviorist, I shouldn't say licensed, certified, because there are no licenses for trainers in Ohio, of course. Working with a trainer that, we have this process underway, that they should be allowed to do that within reason, of course. So I think, unfortunately, we're going to see a lot more of the dogs that are coming in from cruelty cases not making it out of the shelters alive, especially those dogs who lack socialization. So the dogs who are chained up outside, the dogs who are living in hoarding situations, who may bite from fear or other, non-contact. I think that's going to negatively affect those dogs who, in the past, a lot more shelters and rescues felt safer rehabilitating those dogs and placing them in homes. Now we're not willing to accept the risk. So just some unfortunate consequences for dogs who are not necessarily bad dogs.
One of the ways for the shelters and the pounds to protect themselves is going to be common sense. If a dog is very aggressive, if it has a history or anything like that, that is a dog that should not make it into an adoption floor. That is a dog that should be humanely euthanized. But is there anything that shelters can do currently under the current law to protect themselves, or that they should be doing outside of, I guess, for the dogs that they don't know that they would be a concern?
Yeah, so of course, there are those 4 questions that have to be asked, on intake if they want that little bit of extra protection. But they can ask additional questions too, beyond that, of course. They can have behavior policies within their shelter about how they assess dogs and their suitability for adoption. They can have euthanasia policies for how they decide things like behavioral euthanasia. They can work with trainers to have expert assessments on dogs to help limit their risk, especially in, situations where maybe they're not sure. Maybe they have a dog who's a little bit fearful. They think, maybe this dog is capable of biting. Have it assessed by a trainer. See what they think. That protects the dog. It protects you. That's a good thing to do. Of course, just same with veterinarians, liability waivers are very important. Making sure that, those waivers are in place and that all of the behavior is disclosed. Most often when we see lawsuits with big payouts, it's because someone didn't disclose the dog's behavior and they knew that dog had dangerous behavior. So they knew there were prior bites or prior incidents and they weren't disclosed to an adopter. That's where we most often see problems. So that should never be done. You should absolutely be transparent, with adopters, with foster homes, with anybody who comes into contact with a dog. And ultimately, it's going to be an assessment of risk. We've seen some shelters now who say, well, we're no longer doing doggy daycations because these are people coming in off the street, taking a dog out on a day trip, and we don't know what's going to happen, right? So we've seen those programs eliminated in some situations because the shelter is simply not willing to accept that risk. And that's just an assessment of what they're willing to accept. I've heard from other shelters where they've made the decision to euthanize dogs who are leash biting playfully. They're saying that's too much of a risk. So risk tolerance is an individual decision for every single shelter. There's no right or wrong answer, but I've seen both extremes now. I've seen, it going very, very extreme to, any dog who puts their mouth on any person or any other animal is euthanized, no matter the circumstance, right? And I've seen the converse where people are still fighting and saying, I'm not euthanizing any dogs. And I think that's going to be a, ticking time bomb, unfortunately.
Is there a time frame? Let's say, I go in and I adopt a dog from the shelter and 3 years later it bites somebody. Can that still come back at the shelter? Or is that now, considered, I've had control of this dog?
Here's the problem. People can sue anybody for anything.
Right.
It doesn't mean they will win. However, we have seen lawsuits arise many years after a dog is transferred, either privately or through a shelter, where they say, well, this is your fault. You adopted me this dog and now it bit somebody 5 years later. And it's like, wait a minute, we haven't had anything to do with this dog for 5 years. Probably not going to be super successful, but that doesn't mean it won't happen, right? So the other thing, that's really important is making sure you have insurance coverage, because otherwise you're paying out of pocket to defend those cases, and that's never a good thing. Insurance companies will appoint an attorney to represent you as part of your policy.
So what are the questions on Avery's Law that everybody should be asking?
Okay, so shelters, and I'm going to put my asterisk after that, because the law is also not clear whether or not this applies to foster-based rescues or not. So it may only apply to physical shelters. However, shelters who harbor dogs get limited protection from criminal liability if they ask these questions. The questions are whether the dog has ever chased or attempted to attack or bite a person. Number 1. Number 2, has the dog ever bitten a person? Number 3, has the dog ever seriously injured or killed a person? And number 4, has the dog previously been designated a nuisance, dangerous, or vicious dog? And then you have to get the details for all of those. So those are the questions. Now, what you'll notice is those questions don't ask anything about provocation. So they don't even necessarily fit the designation categories. Now the questions that are coming in are, did your dog ever bite a person? So this doesn't ask necessarily about the situation where you're a vet treating a dog and the dog bites you. Now the person has to disclose that because it doesn't matter whether or not the dog was provoked. And then how does the shelter decide what to do with that dog? Now, the dog is not declared dangerous, but the answer to the question was yes. What now? I don't know. The law doesn't say. So it's going to be a risk tolerance question of, do we still accept this dog? And if we accept this dog, what do we do with it?
I guess one of the best examples is going to be the dogs that have warnings on our computer system that is like hates nail trims, right? So the dog is perfectly fine for everything. It licks your face and you can give it treats and it's the best dog ever. And as soon as they see the nail trimmers, it becomes like Cujo.
Yeah.
And but then we know about this and we manage different ways. But yeah, that's, we know that this is what makes the dog not happy, so then we manage it.
Yeah. So it doesn't make a lot of sense. I mean, if anything, the question should mirror the actual designation language. That way it's clear, what they're accepting as a dog who maybe even though it wasn't designated, should have been designated. And then that helps to them to form a better risk assessment. Because right now what we're seeing, especially on the question of, has your dog ever chased a person? Well,
Right.
what does that mean for me? What does that mean for my dog if my dog has ever chased a person? And it doesn't mean my dog chased a person in an aggressive manner or a menacing fashion. It just means, as it says, has my dog ever chased a person? Well, does the shelter take that dog in when I answer yes to that question? It's not really a fair assessment of the dog's behavior, coming in at the onset. And it doesn't make a lot of sense. So, there's certainly some revision needed to the questions to better capture the behavior we are trying to reveal when we're talking to a dog owner about whether or not we're intaking those dogs.
Well, and I guess as far as has the dog ever caused an injury, dog's nails were long and it jumped on somebody just to greet them and scratched their arm. Like, I wouldn't consider that the dog causing an injury, but literally the dog did cause an injury.
I mean, what dog has not caused an injury, honestly?
Right.
Like, seriously. I don't know of a dog who hasn't at some point in their life scratched a person.
Right.
Either out of play because they're so happy and they're jumping up, or because they're teething puppies. Right? Like,
Right.
I simply don't know a dog who hasn't caused an injury. And that is the inherent nature of dogs. Like, they are animals. Yes, there are companions, but they are animals. And it seems like we may have now forgotten that fact, that we need to accept that they have a nature that is inherent of dogs. And that is something that we, as a society embrace and bring into our lives, that we are now saying, now you have to answer yes on this questionnaire saying your dog has injured a person if your dog has ever jumped up to greet Aunt Sally and accidentally nicked her leg because you just freshly trimmed his nails and you left him a little too sharp.
Right. Or I have a toddler and I have my big dog and the toddler got pushed by the dog and fell. Then that dog injured my toddler, even though it was just walking and not really doing anything to the kid.
Yeah, I mean, that definition is the most dangerous definition. To not have that defined as a bite is really dangerous. I mean, we have cases right now where there are scratches and those dogs have been declared dangerous. They have to get $100,000 of insurance on their dog, restrict their dog, get a special tag, keep their dog confined in certain ways because their dog scratched somebody. I mean, that can't be the intention of this law. It simply can't be.
Well, and how easy is it to get insurance anymore?
It's not. So there are companies out there that specifically offer, this insurance, but it's not cheap. So you have to factor that in. Now it's going to cost you, maybe $1,000, maybe $2,000 extra a year to keep your dog. So, do you keep that dog? I don't know. It's a personal decision people have to make, but to say that dogs who are doing things like scratching people, or my absolute favorite, by the way, I had a dog who had no teeth. It was like a senior dog and it gummed a lady in the hand. Like, I'm not joking. The dog had no teeth. It left a bruise on her hand. They declared the dog dangerous. And I'm like, is that really the dog who's going to harm a person? The dog with no teeth.
Now, are the questions that we discuss, are they the same across the board? Are they the same questions that like veterinarians need to be asking?
So there's no exception for veterinarians, even if they ask those questions, unless perhaps they are veterinarians who work in an animal shelter. That's another thing that's not clear, is if veterinarians who work Like if there's an animal clinic at an animal shelter, do they have to ask those questions in order to get the heightened protections? So that's not clear. My recommendation is yes, that they ask them anyway. Veterinarians can absolutely ask those questions. It's not required. Is it a good idea? Probably, just so that they know what they're dealing with, to help limit, their liability that way.
In Ohio, veterinarians are mandatory reporters. So does this change reporting? Like, who is responsible for reporting if a dog has bitten or scratched?
So there's an interesting issue when it comes to veterinarians and language that was put into Avery's law, which is RC 955.61. And what that says is that if a licensed veterinarian has knowledge of a person being bitten or injured as a result of an attack by a dog or other non-human mammal, the veterinarian has to report the bite or injury not later than 24 hours after obtaining such knowledge, which is different language than what exists for veterinarians under the Ohio Administrative Code. So the question is, what are veterinarians required to report under 955?
Right.
Are they required to report an active bite, or are they required to report if anybody comes in and says, yeah, my dog bit somebody 5 years ago and I'm here for a behavioral consult? Is the vet required to report that? That language is not clear. What we've heard from some of the legislative drafters is that the intention was not to create new duties, but the language doesn't necessarily say that. And there's no reason that the language in 955.61 is not identical to the language in the OAC. So the question remains, what are veterinarians required to report? Certainly it sounds like they're required to report a bite that happens, in their presence for purposes of rabies quarantine. Not for purposes of dangerous dog stuff, because it does get reported to the health commissioner, right? Not to the dog warden. Where the report goes from there, is another question. Most likely it's going to the dog warden, which means, it's getting reported that way. But I have heard from veterinarians who have said, I'm not going to report a dog who bites in my clinic that I'm performing treatment on when I feel as though that bite was provoked. I'm not doing it. I've heard that. And I understand how difficult that is, because, you don't want to put your client's dog at risk of a designation that it doesn't deserve, right? So I'm hopeful that some legislative changes will be made there to better clarify what veterinarians are required to report, because right now I think it leaves the door open.
There is a difference between the dog that is really happy and jumped on me and scratched me. I don't consider that an aggressive behavior. And I was injured because I have a scratch, but in my eyes, that dog was not being aggressive. That dog was not being a nuisance. That dog was not being a problem. So, like, where do you draw the line?
Yeah, I mean, it doesn't make a lot of sense to me. Like, again, when we think about legislation, legislation should be effective. And I think having veterinarians report every instance, like you just described, is not effective legislation. I mean, it's just, what we're trying to capture here are dogs who are not safe to have in the public. But we're capturing a lot of dogs beyond that with the current language. So, yes, veterinarians, may have questions about what they have to report and don't have to report. Obviously, I encourage veterinarians to err on the side of caution, because there could be consequences for them if, there is no report made. But right now, what the law says is if there is an attack by a dog, whatever that means, you're supposed to report it.
So I guess if I don't consider it an attack.
Legislative interpretation.
Right, I know. So is there any hope that things are going to change, that this law is going to become more common sense, or is it likely that this is going to stay as is for a long time?
Unfortunately, one of my major issues with the way the legislature works in Ohio is that it doesn't really allow for participation by people. Notices of hearings happen very quickly. There's a very limited amount of time to get down to Columbus and submit testimony or do any of those things. And if you're not carefully watching the legislative system, you're going to miss those opportunities. And that's largely what we saw here. This bill flew through the legislature. it went really fast. There wasn't a single opponent testimony. So in their minds, they're thinking, great, nobody opposes this. But in reality, a lot of people didn't know it was happening.
Right? Nobody had the opportunity to oppose it.
Yeah, or they didn't understand the language itself. I mean, this is a lengthy bill. I have read it many, many times. And every time I read it, I'm like, didn't see that the first 72 times I read this, right? Like, it's just so dense. So I don't think people's silence was acceptance. And I think that is now being heard loud and clear. And I am hopeful that legislators will hear that and realize that some common sense changes need to be made. Again, I don't think there's a single person out there who is going to say, we think dangerous dogs should remain on the streets unchecked. I don't think those people exist deep down inside. So I think, that being the case, if that's the position we start from, is truly addressing dangerous dogs, then we can come to a solution. I just think at this point, we've missed the solution. We just have to, make some changes and get there in an effective manner that truly addresses the problem. Because, serving a bunch of papers that say your dog is dangerous, have a nice day, is not going to have the intended effect.
So as I mentioned in the very beginning, it's kind of like good idea, but poor execution, because we address the fact that there needs to be a consequence for dangerous dogs, and dangerous dogs should not be allowed to harm the public. But the definition of what dangerous dog is just too inclusive of pretty much any dog.
Yeah, it's just too broad. And, to be fair, the sponsors of this legislation did try to narrow it. So they included things like playful behavior or non-aggressive behavior, but it's still not specific enough. It's just still not there. So, we need to include some other things to truly address, dogs with dangerous behavior. And I think it's possible. We just have to have, legislators who are willing to do it. So, of course, people should speak to their legislators about making common sense changes to laws like this. Absolutely. Because if they don't hear it from their constituents, they're on to the next thing, right? They're moving along, passing the next bill. So, people really do have to speak up when they see problems like this.
If anybody that's listening wants more information or has issues concerning dangerous dogs, where can they go?
Yeah, so of course we're always happy to, talk to people about, what Avery's law does and what other laws do in Ohio. Another great resource is the Ohio Animal Welfare Federation. In fact, I did a seminar on Avery's law with them that is recorded and in their library for members. So that also exists out there that gives you a broad overview of what the law does. But other than that, I mean, if, your dog has an issue, you need to get an attorney fast is the bottom line. Do not sleep when you get a notice, because you only have 10 days to appeal that designation. And if you don't, the designation is permanent.
Well, thank you so much for being here and for all this information. And to everybody listening, please be careful, be smart, and thanks for listening.